Great. Well, let's kick off, shall we, for our immigration update webinar, part of our new series of People Matter content that we're putting out there. So the idea is to have slightly snappier content, a bit more frequent. So this is a 45-minute webinar. Some of our webinars will now be only half an hour, but the idea is we'll do things a bit more frequently, a bit more topical, and hopefully a bit more accessible, so that not everyone's committed to an hour, which is not always easy to do, is it, in a working day. Just in terms of a little bit of housekeeping, we'll have a recording available of this webinar afterwards. That will be sent out and available. And if you'd like to ask any questions as we go through, please do feel free to do so. Pop them in the Q&A box, and we'll see if we can pick up some at the end, try and work through some of the common themes or topics that are coming through in those questions. We have got a lot of people on the session today, so if we don't answer your question, it's nothing personal. It's just that we probably haven't managed to get to it, or we're just sort of working through a lot of them and trying to pull out the ones that have got the common themes from today. Great. So what are we going to be doing today? We're going to do a couple of topics, actually, a little bit of detail. So look at hybrid working and sponsor duties in that area. That's obviously an issue that is relatively new. The way of work is changing, as we all know, post-pandemic, new ways of working, hybrid working, agile working, and whatever you want to call it. And there's been some uncertainty, as you may be aware, for a while around, well, how do sponsors handle that in terms of monitoring, reporting, and notifying of changes of work location. There's been some new guidance issued around that, so we'll look at that in a bit of detail. I then thought we'd look at the issue of clawing back of immigration fees. So lots more employers are in the situation of having to access or wanting to access the global labour market, obviously EU nationals in scope for skilled worker visas as well. And the costs are going up significantly for many businesses related to that. Cost for each visa, can be several £1,000s. And so lots of organisations are looking at, well, can we try and mitigate those costs somehow? Can we manage those? What about clawback options? We're going to look at some of the issues and the risks and considerations around that. And then we'll do a bit of a roundup towards the end. So we'll look at some other changes, particularly in the skilled worker category, that have happened since our last webinar update in January this year. And we've also picked out a topical question around right to work checks for student visa holders. Mark will pick up both of those items in item 3 towards the end. As I say, if you've got any questions, pop them in the Q&A feed and we'll see if we can pick them up. Just before we get into all of that, I thought I'd reflect on a few recent sort of policy and statistic announcements, just to give a flavour of the current immigration landscape, and particularly the backdrop, I suppose, to some of the policy decisions that the government is facing. We had some quite interesting statistics come out to the end of March 2023 around visas. I'll sort of throw a few of those out there so you get a flavour for what's going on. So there were 299,891 work visas in the 12 months to the end of March 2023, and that is 61% higher than the previous year. So, very significant increase there. Straightforward skilled worker visas increased by 59%, and there was a 171% increase in the skilled worker health and care visa, largely due to the expansion in care workers. So a real, notable increase in the number of work visas being issued. Also significantly, there were almost 150,000 visas for dependents of students that were issued, up from only just over 72,000 for the previous year. That is obviously a significant increase, takes a real chunk of the total number of visa numbers, and does form a backdrop to some of what Mark will be touching on later around some announcements the government has made around dependents of student visas. There are a total of 2,836,490 visas granted in 2022. But interestingly, when you break that down, around half of those are for visits, so visitor visas, 22% students, so that's already taking you to almost 3/4. Only 15% were work visas, and some other categories in the mix as well. All against, net migration up to just over 500,000. So there's obviously real pressure on the numbers, difficulties the government's grappling with in terms of managing kind of economic growth agenda issues, kind of climate around wanting at the same time from their perspective to keep migration numbers under control, but the work visa percentage is still relatively low. It is some of these other categories, particularly study-related visas, where it is much higher. And as I say, that does form the backdrop to some of the announcements that the government has made about some potential future changes. Just moving to the spring budget that we had in 2023, again, a real emphasis there on employment, education and enterprise as priorities for delivering growth and building a high-wage, high-skill economy. And perhaps most significant in that was an announcement by the Chancellor to look to simplify the business visitor rules, or the visitor rules, as they should probably be called, potentially from the autumn of this year. And there was a mention there of expanding the range of short-term business visitor activities, a recognition they're perhaps too restrictive at the moment, and those of us advising in that area, those of you that are trying to grapple with, is an activity the person is going to be doing a permissible visitor activity or not? How do we manage this in terms of the degree of risk aversion we take? All quite difficult. That is going to be looked at, potentially expanded and hopefully simplified. Of course, the proof will be in the pudding, as always, but that is on the radar, and also a review of the permitted paid engagement category of the visitor rules, which is particularly relevant for higher education institution colleagues amongst us. So we've got this context, haven't we, of quite a significant increase in migration, increase in the number of work visas. There's still something of what some people would see as a hostile climate around immigration, though, and the government having to work with the grain of delivering to political priorities in that respect, perhaps, whilst also at the same time managing the growth agenda. That's the context really to what is going on. So turning to hybrid working, so this has been a really tricky issue to be sort of managing as a sponsor, and still remains, I think, a little bit unclear, frankly, in terms of what you should be doing. So I thought I'd run through the changes that we've had to the sponsor guidance and think about some of the practical considerations in terms of implementing that for you as employers. So the changes are in part 3 of the sponsor guidance. So if you want to look them up, you can do. There's a new section around this. What is the obligation to report in this area? I'll put it there on the slide. So you've got an obligation to report a change to the normal work location that's stated on the certificate of sponsorship. And there's now a bit more detail saying this includes where the person will be working from a different site, branch or office, or at a different client site if they have to be working there for a while, or remotely from home on a permanent or full-time basis with little or no requirement to physically attend a workplace. Or perhaps most fudgy of the 3, the hybrid working pattern. If it's a hybrid working pattern, that should be reported if you'll work remotely on a regular and planned basis from home or another address, which is not a client site or an address listed on the license. And obviously those reports have to be made, change of circumstance reports via the sponsor management system within 10 working days of the change. So you can probably see that the difficult one here, or the slightly grey one, is the hybrid working pattern. You know, what is a regular and planned basis from home or another address? And to confuse the matter further, there's been some quite well publicised around the legal advisor community that the business help desk at the Home Office has actually said that it doesn't want reports to be made where a worker is following a regular pattern of hybrid working. In that situation, they're not required, said the business help desk, to report. Instead, the employer sponsor should just be retaining relevant evidence of hybrid working, which they can then show on a compliance visit, probably to explain, you know, how they're still fulfilling monitoring duties and where the person is actually working. Temporary changes to work location that are not part of the regular pattern, they don't need to be reported. So we're in this place where, okay, well, around the hybrid working pattern, what do businesses and sponsors have to be doing in that area? That is the one that's a bit unclear, isn't it? So what are the considerations that come out of that? I think the first thing is, it's going to be a good idea, if you've not already done this, to review all of the work locations that you've got on the certificates of sponsorship of the staff that you sponsor. I think it's good practice to do that on a regular basis anyway, a kind of mini audit in that area. You know, are they up to date and correct? Have you got new work locations which somebody is now working at and which should have been reported anyway? Do you need to be adding other work locations as branches to your sponsor license? You know, that may well be appropriate to do. Are there new working patterns that at least need to be considered? If you've not done that, I think it's sensible to be doing that. I suppose the second blob is around, well, what do we have to do in terms of the reports? And I've tried to summarize it in a helpful way, in that I think to be on the safe side at the moment, it is sensible to report on all locations which are part of somebody's regular working pattern. So a temporary change, you don't have to report. A regular, agreed, documented pattern, Monday, Tuesday, work in the office, Wednesday, Thursday, Friday at home, that should certainly be reported. I guess lots of the questions around the more ad hoc stuff. So you have a hybrid working policy, people work different days each week in the office and out of the office. You know, what should happen in that situation, particularly given the apparent additional guidance issued through the business help desk. I think it remains on the safe side and the cautious side and the sensible thing to do until this is formally clarified further in updated policy guidance, to still be reporting the different work locations where somebody is regularly going to be working, let's say from home. So if you've got, let's say, a working pattern where, you know, it's 60-40 in the office and to home, but there's flexibility around the 40% of days spent at home, let's say, I still think it is sensible at the moment to be reporting on that. Some might say, is that overly cautious? In light of some of the guidance that's been issued, I think given what is in the sponsor guidance, that is a sensible thing to be doing. Generally, if in doubt, I think making a report is sensible. It's not a hugely onerous thing to do. Those of you that kind of read around these things might have read some stuff around if somebody's working at home regularly or most of the time, you know, is there a need for sponsorship? Is the Home Office going to question whether or not a work visa is necessary? I'm fairly relaxed about those sorts of points. I don't think that's something that you need to be getting concerned about. It's going to be pretty easy to identify reasons why somebody needs a work visa. They're going to be attending meetings in the UK regularly in connection with their work, and they're paid from the UK. Sponsored, you know, working for a UK employer, clearly coming in as a visitor wouldn't be appropriate. There'll be stuff around managing your international compliance obligations around tax, social security, all those sorts of things. You want people to be in the UK working. The fact that they may be spending most of their time doing that on a remote basis, I do not think fundamentally creates problems in terms of them being sponsored for a skilled worker visa, albeit I appreciate there are some different views out there on that. And finally, I would say, if you're wondering, well, you know, we've had these patterns going on for a while, what should we do? In general, a late report is better than no report. In my experience, frankly, and I've been doing this game for a while, I've been involved in lots of audits over the years that the Home Office have attended. Change of circumstances reports don't tend to be issues that, on a practical level, the Home Office tends to get that concerned or excited about. If you identify something and it's late, better still to report it than not at all. If you don't report when you should have done, having identified it, that would be more of an issue. And I think particularly in this context, if you're thinking, well, we're not really being sure what to do, we now want to err on the side of caution, is there a bit of risk attached to that? I think the right thing to do is to report. And in practice, I suspect the risk associated with that should be low. I'd also add, I think it is likely that we're going to get further clarified sponsor guidance at some point soon. It's not really very adequate at the moment, what we've got. I don't think the Home Office wants lots of sponsors to be making lots of reports on the system on stuff they're not really interested in. So I suspect it may be further clarified, but at the moment, that would be my recommended course of action. Great, so turning to our second topic on focus on fee clawbacks. Quite an interesting area, this. I mean, the average cost of a skilled worker visa, if you think about it, can be heading towards, you know, £10,000 or so if you as the sponsor and employer pick up all of the costs, so all of the sponsor related costs, and you also reimburse the applicant for their own fees as well, which I know that some of you will be doing. It's a significant upfront investment, but people come and people go, people leave having paid some significant costs, and you know, you need to be attracting people in. So it's difficult to know how to handle this. You know, some people say, well, we want to put restrictions on sponsoring people for work visas. We don't want to do that unless we absolutely have to do so. But that takes you potentially into race discrimination territory. If you are refusing to sponsor somebody for a visa, in circumstances where you've got a license, you can do so, the role qualifies, and they're the best person for the role. So that kind of more restrictive approach to the issuing of visas, if you like, is fraught with risk, notwithstanding, interestingly, that the government seems to promote looking at the settled workforce first in some of its online guidance, which is clearly not consistent with the immigration rules or the law around indirect discrimination. So the other area that people are looking at is around clawback of fees, and we've certainly had more queries in this area recently. To what extent can a sponsor look to claw back costs from somebody who's sponsored in certain circumstances? What's the position on that from an immigration compliance perspective? And what are some of the other considerations, the broader issues to be thinking about if you're looking at implementing some sort of arrangement on those lines? So just in terms of the immigration compliance stuff first, what is not permitted in any circumstances is to seek to recoup the immigration skills charge. That's the bulk of the cost, isn't it, from your perspective as a sponsor, of up to £1,000 per year. It's less than that if you are a small business, charity status and so forth. That's the bulk of it. It's expressly referred to in the sponsor guidance that if you attempt to claw back, that is a serious compliance issue that may result in the revocation of your sponsor license. So that's a no-no. The ones that are permitted are there on the left. So the certificate of sponsorship fee of £199, you're not prohibited from reclaiming that. I would question whether that is worthwhile, whether it's quite the right thing to be doing, given it is an employer-related cost, but technically that is permitted. Application fees that you have reimbursed, let's say, the individual as part of the process, you can seek to recoup those. There's no prohibition on doing so. So that would obviously be the visa-related fee. That can be significant, can't it? So a 3-year in-country application, that's 719. If you pay a priority service on top of that, you've got another 573. So north of £1,000 for a 3-year visa on that. And then the immigration health surcharge on top of that, up to £624 a year as well, payable up front, so a significant sum. If you reimburse that, potentially that is also in scope for recoupment. But it is worth emphasising that the issues here are broader than just what is and is not permitted from an immigration perspective. And there are some things you want to think about quite carefully if you're thinking about introducing this in some way. I'll put some of the main considerations there on the slide. I think the first one to really step back and think about is what is potentially the practical value of seeking to have some recoupment provisions. If you can't take the amount from the final salary of somebody because they're not earning enough, let's say, are you really going to be suing for breach of contractual provisions if they refuse to pay up? Might it have a deterrent effect on recruitment in what is still a relatively hot labour market? And it may well not deter people from leaving in any event. They're probably just thinking, well, actually, the employer is never going to come after me for a small number of thousands of pounds at best. So I'm not really worried about it. So I think you have to question, is it really, it might make you feel a bit better as an employer, but is it going to be a lot of practical use? You've got enforceability considerations to think about as well here. Clearly, you have to document it quite carefully. I'll come on to that in a moment, but that's going to be either in the original contract of employment or in a side letter that goes along with the contract. And you'd also have to, if you're wanting to make deductions of outstanding amounts from someone's final salary payment, which would often be the case, you need to make sure that your deductions clause in the contract covers the ability to deduct these sorts of amounts from that final salary payment. Not all deductions clauses will do that, depending on how they're drafted. And there may even still be an argument around, well, even with everything well documented, is this enforceable? Or could it be a penalty clause or be in restraint of trade and therefore be void? There are arguments that may be the case, depending particularly on how those provisions are drafted. Key to that, moving across the slide, is the proportionality issue. You'd need to be adopting, to put yourself in the best position in terms of enforceability, a proportionate approach to making recoupment. So tapers, based perhaps on length of service with the employer, sunset provisions where you would no longer after a certain date seek to recoup certain amounts. So essentially over time, the amount that is owed, if you like, is reduced. You'd also think about, well, what are the appropriate termination triggers here? It's not really going to be appropriate, is it, to be demanding recoupment in circumstances where you, the employer, have made the person redundant, let's say. You'd wanting to be doing it in circumstances where the employer, if you like, is at fault. So at fault in, and speech marks. So they have resigned or they've been dismissed for conduct or capability issues. So thinking about the circumstances when such provisions would bite. We've always got to have a bit of an eye on indirect discrimination as well in this area. So quite possibly a policy where you're seeking to recoup these fees from foreign nationals could be indirectly discriminatory, race discrimination. You can, of course, objectively justify indirect discrimination. So you need to be doing some work around that case. So thinking about, okay, what are our reasons? What is the aim of this policy? Why is it proportionate that we're applying these sorts of provisions in this kind of way to meet that aim, so that you're in the best possible position to justify, objectively justify indirect discrimination in the event that claims are brought. Probably not a high practical risk, but certainly the basis for an argument there. And finally, if somebody is low paid and you're looking to make deductions from somebody's final salary payment, let's say, or indeed more broadly, you need to be careful around, are the national minimum wage requirements still met? You know, by making the deduction, are you taking the person below the national minimum wage thresholds? So those are some of the things to be thinking about. I think in summary, think very carefully around the real value of seeking to include these sorts of provisions, and indeed what the negative effects could be, say, but particularly around recruitment and retention, because it's probably fair to say they're still not of huge use across many sectors. If you are going to implement some provisions, they do have to be carefully thought about and drafted and have a proportionate approach in terms of the amounts that you're seeking to recoup. And it's also sensible to be recording the reasons why you're making this policy decision, so that you're in the best position you can be to deal with any claims that may be brought on this point. Good, so that's enough from me on those two topics, hybrid working, sponsor duties and fee recoupment. We might pick up some questions around those towards the end, but in the meantime, Mark, over to you for a bit of a roundup on some other news.
Yeah, thank you, Alex, and good morning, everyone. So I'm going to take through just some of the most recent changes, some of the headlines in terms of visa policy and some of the practical changes that we've seen over the last couple of months. Beginning with the reforms, or rather the proposed reforms to the student visa category. And Alex has mentioned this already at the outset. So as most of you will be aware, the Home Secretary published a statement around about a month ago, setting out some proposals in terms of changes to the student visa category. Now, there's a lot of proposals that are being explored at the moment, but we've listed the three key proposed changes on the slide here. The first is to restrict a student's right to bring their dependents with them to the UK when they're coming over on a student visa. So at the moment, it is the case that a student can obtain a student visa and also apply for their direct family members, so their spouse or partner and children, to come to the UK with them, and those individuals would hold dependent visas in the UK based on the student visa held by the actual student. The proposed change is that the only students who will continue to be able to do that will be those who are studying on postgraduate research programs. So obviously what that means in practice is the vast majority of student visa holders would no longer be able to bring their dependents over to the UK. And the policy reason here has already been touched on by Alex earlier on. The Home Office obviously are looking to bring down net migration, and the amount of dependents coming over with student visa holders has rapidly increased. I was reading that the Office of National Statistics have estimated an increase in use of 750% over the last 4 years. So the Home Office are clearly looking at this as a way to actually bring down that net migration number. So that's the main change. There are some sort of ancillary changes that will have potentially significant impact on the eligibility criteria, most notably a review of the maintenance requirements. Now, we don't know what that yet looks like, but I think in practice, and bringing this back to kind of the policy considerations and the context behind these reforms, the Home Office don't appear to be looking to reduce the number of student visa holders. They still want to be attracting talent to come and study at UK universities. So realistically, I wouldn't expect any significant changes to maintenance from an eligibility perspective, probably just some tweaks here and there. And then the final key reform that is being considered is to require student visa holders to actually complete the course of study for which their student visa has been granted before they are permitted to switch into an alternative immigration category. So by way of example, a student visa holder would be required to complete their course and graduate before they could switch and obtain a skilled worker visa, whereas at the moment, they could theoretically begin their course and then 3 months later switch into the skilled worker category, assuming that all of the requirements for the skilled worker visa were in fact satisfied. So those are the key changes. Now, the important note here is that, you know, they are still proposals. The immigration rules haven't changed in any way yet, and the Home Office are currently consulting with various stakeholders on these matters. The Home Office have confirmed that the earliest that we'd see any changes introduced would be January 2024. So we have, you know, at least 6 months for this all to be ironed out. In terms of kind of the key impact here, I think the main point is that, you know, we have seen this increase within the use of dependent visas. And as I've said, the Home Office's policy is not to reduce the amount of students. An unintended consequence could well be that we see less student visa applications because those individuals who may have wanted to come to the UK now no longer want to do so because they know that they can't bring their husband and kids with them, for example. Obviously, all of that remains to be seen, and it's very much a watch this space, but we could be seeing some significant changes early next year. Moving on now to look at some of the practical changes we've seen. The Home Office have implemented some quite significant changes to the way in which sponsors are interfacing with them, particularly through the sponsor management system. So we've recently had an update to the way in which requests to change certain key personnel on a sponsor license will be implemented. It had been the case that if you wanted to replace your authorizing officer or your key contact on the license, or indeed if you wanted to add additional level 1 users to the license, you would make that application from within the license, and then that would be sent to the Home Office and processed manually, and could take up to 18 weeks if you're not making use of a relevant priority service. What the Home Office have now done is automated that system as far as possible. So if certain criteria are satisfied and you make one of those requests to, for example, replace your authorizing officer, that will be automated, provided that the license is live and has an A rating, which is going to be the case for the vast majority of licenses. And more importantly, provided that the new authorizing officer's information in terms of their work address matches the information already associated on the license. In short, their information is clearly that of someone who is working for the business. And the specific practical point here is that the postcodes have to match. So the new authorizing officer's postcode has to match the postcode of the business as listed on the license. If that's the case, then it will be immediate and you will have your new authorizing officer. This does also extend to legal representatives. So where, for example, we are acting as a legal representative on a license, our address is associated with that license as well. And so if we were to add another one of our colleagues as a level 1 user on that license, again, the addresses would match, the postcode would match, and that would be automatic. So this is really good news. As is often the case when replacing an authorizing officer or key contact, time is of the essence, and the fact that this is now all automated and very straightforward is a very welcome change. Moving forward now onto changes to the priority service. So the Home Office undertook some maintenance on their sponsor license application portal. Without giving us any prior warning, a couple of weekends ago, the entire system went down for the whole weekend. And when it came back up, there were some minor tweaks to how sponsor license applications actually work. The most important change that they made is that it is now possible to request use of the priority service via the system itself. Prior to that change, it had been the case that when you're applying for a sponsor license, you submit the application online through the application portal. You then have to email the Home Office every morning at 9 a.m. if you want to use the priority service, and say, we would like access to the service, please. And it was dealt with on a first come, first served basis with 30 available slots each day. So you can now deal with that through the system, which obviously is good news. You don't have to email the Home Office on a daily basis, but in practice, it's actually not as significant of a change as we might have hoped. The Home Office haven't increased the number of available priority slots. It's still set at 30 per day, and it's actually still operated on a first come, first served basis. So the only change is at 9 o'clock every day, instead of emailing the Home Office to request permission to use the service, you log into your license application, click on the pay priority button, and if you are one of the first 30 people to do so that morning, the system will allow you to pay. And if you are not, the system will say the priority service is not currently available. So not actually as helpful as it first appeared. What I would say is, if and when the Home Office expand the availability of the priority service, the fact that this change has been made will become increasingly significant, because it will allow sponsor license applicants to kind of manage that themselves and not have to email the Home Office directly. And then the final change in relation to the way in which we are interfacing with the Home Office, there has been an update to the automatic renewal of annual allocation for certificates of sponsorship. And the certificates of sponsorship that we're talking about here are either for skilled workers who need an undefined certificate, and that's those who are already in the UK and transferring either from another employer or renewing their current visa, whatever that might be, or some other sponsored categories such as the Global Business Mobility Senior or Specialist Worker category. For those types of sponsorship, you will have, as a sponsor license holder, an annual allocation of certificates of sponsorship. And although you are able to increase that at any point during the year, the theory behind this annual allocation process is that you ask for how many you should need over the course of the year, and then you make use of those, and then it renews at the end of the year. Previously, and for a long time, it's been the case that most sponsors have to go through that annual renewal process manually. They have to identify how many they're probably going to need and ask for that number and justify that number. The Home Office did allow for automatic renewal for certain sponsors, primarily those sponsors that are making a lot of use of the system at quite a consistent level. The change that we've seen is that it is now the case that all sponsors will benefit from automatic renewal, as long as your current allocation is set to live, which it will be if you've made use of your license in the last year. When your annual allocation expires, it will renew automatically based on how many certificates you assigned during the preceding 12 months. Now, to be clear, you can still request additional certificates at any point. That hasn't changed. This is just taking out the additional administrative step of manually requesting more on an annual basis. And then a final couple of points just relating to kind of some ancillary changes around how the Home Office is working. We are expecting a review from the Migration Advisory Committee in relation to the current shortage occupation list. That should be coming out later on in the year, so potentially some changes coming to which roles are classified as shortage occupations and which are not. Obviously, we will keep you updated on that during future sessions. And then finally, we have seen some changes to processing times recently, most noticeably around in-country applications. The good news is that family visa applications made from within the UK have seen processing times reduced from 9 months, which was obviously a significant period of time, all the way down to 8 weeks. So that's really great news. The less good news is that health and care visa applicants, the processing times there have now formally increased from 3 weeks to 8 weeks. I would say in practice, it seems to be the case that health and care visa applications are still being processed around about the 3-week mark, even though the formal processing time has been increased. So generally speaking, what that means is more or less across the board, in-country applications are being dealt with in around about 8 weeks. That's kind of the standard processing time now. And then the final thing, just to pick up on, if I could have the next slide, please, Alex, is in relation to right to work requirements for student visa holders. So we've included this because it seems to be something of a hot topic. We've had quite a lot of questions around this issue recently. So we thought we'd just tackle it briefly for you. Now, as many of you will be aware, student visa holders have certain restrictions on their ability to work in the UK. The standard restriction that applies to the vast majority of student visa holders is that they can work in the UK, but during term time, they are restricted to working 20 hours per week. When you are employing an individual who is currently here as a student, your right to work checks will begin in the same way as any visa holder. So the process that you're using is the online right to work check because they're a visa holder. They will use their visa to generate a share code. You will then use that share code to complete the check. And when you conduct the check, the information you will receive is the normal information about who the individual is and the fact that they have a right to work in the UK. But additionally, because they're a student, it will specify that they are subject to certain restrictions. And as I say, in most cases, that's 20 hours of work in a week during term time. The extra step that you need to be taking because of that restriction is, as an employer, you need to satisfy yourself that any work that is being conducted for you does not breach that particular restriction. In practice, what that means is you need to know whether or not it is term time if you are looking to have that individual working more than 20 hours, or rather you will need to ensure that you are not allowing them to work more than 20 hours during term time. In practice, that means you need something in writing from the university which confirms the course dates for that individual. Now, there is not necessarily a right or wrong answer. This isn't prescriptive in terms of the exact type of written confirmation you need. However, the confirmation does need to come from the university. It doesn't need to come to you directly. You don't need a letter from the university to you as the employer setting out all of that information. Obviously, if you have that, great, but it's not required. It can be indirect. So it could be, for example, you have a candidate who comes to you, they have a student visa, and they provide you with a copy of an email that was sent to them by their university at the outset of their course when they first enrolled, saying these are your term dates. Okay, that gives you written confirmation from the university of what is considered term time for that individual. So it's just about being aware of that and obviously making sure that you are satisfied that the information you've been provided is sufficient. And the point there is that the onus is on you as the employer. You need to make sure that these restrictions aren't being breached. If there is any sort of discrepancy, for example, you might have looked at the term times online on the university website, the standard term times that apply, and then seen information from the individual that contradicts that. You might then be looking at getting something directly from the university just to confirm what the correct position is for that particular individual. But in most cases, I would say it's going to be sufficient to have the individual forward you whatever information they were given by the university when they enrolled. One final point on this, worth noting, where an individual has this type of restriction, you should also be identifying if they're already conducting work for another employer. The requirement is not that they work for less than 20 hours for each employer, it's that they cannot be working for more than 20 hours a week total. So if they already have a job and they're doing 10 hours work for that employer, you need to make sure that you're only employing them for 10 hours there. So there are some additional considerations. Obviously, that particular circumstance is going to be rarer, but you do need to be alive to that fact. And then I think we've got a few minutes left for questions. Yeah. So
thanks, Mark. Well, I'll just pick up on a few questions relating to the student visa right to work checkpoint. There's been a few follow-up questions on that. People have asked about, well, what about sort of research students that don't follow term time dates? What's the position with them? That's a very good point. So different students will have different term time dates depending on the course that they are studying. So as a general principle, undergraduate taught research students, so undergraduate taught students will have their normal university term time date, and that is what the university would confirm. Postgraduate research students doing a PhD will not normally be subject to university term time dates. They will be deemed to be in term time all the way through the year, apart from designated periods of holiday, usually up to 6 weeks, that the institution grants them each year. Again, this is information which the university should confirm in the written letter that would come from them, by the student, confirming what the course is, what the position is on term time dates. That should be set out in that letter, and if it's not, you should go back to the student to ask for clarification to be provided from the university on that. And a follow-up question around that is, what about time spent, after completion of a course? What does that count as? That is counted as vacation time, so you can work, full-time hours in a non-permanent role during vacation dates, which includes time spent after completion of the course. And there's usually a reasonable chunk of time, because of how the visa durations work, where that will be the case. So the key thing, as Mark was saying, is that you get the information on, ideally, university letterhead, which confirms what the term dates are, or what the position is if they're a research student. Mark, any other questions?
Yeah, so just picking up, we had quite a few questions come through in relation to the hybrid working point and around reporting in that area. First of all, a couple of questions in terms of, well, what if we're not actually changing anything in terms of the employment contract? Where does that leave us? And if there's been no contractual change, if the individual is still technically supposed to be working in the office at all times, do we need to make the report? The answer to that is yes. You are not making this report to reflect the contractual arrangement. You are making this report because it is a compliance requirement. As a sponsor license holder, you need to be monitoring and reporting on your migrants. And so if the reality is that they have a hybrid working pattern, and maybe that's been put in place on an informal basis and the contract itself hasn't changed, they're still working on a hybrid basis, and so you still need to be reporting that regardless of what the contract says. We also had a couple of questions around this kind of sticky issue in terms of, well, what do we mean by a temporary change, and where does the Home Office draw the line there? The honest answer is we don't really have a satisfactory guidance on that. What I would say is the wording here within the policy guidance is that you need to be reporting a change to normal working pattern. And one of the questions in particular gave the example of, well, what if someone temporarily works overseas as part of their job for a set 3-4 week period? Do we need to be reporting that? That wouldn't be a change to their normal working pattern. That is a very clear, distinct temporary change, and so that wouldn't be necessary to report. I think if in doubt, as Alex has sort of said, it's better to take a more cautious approach with this sort of thing. But realistically, the changes that the Home Office are looking for are changes that are going to be long-standing. So an ongoing hybrid working pattern, yes, you need to be reporting that. If you have an employee who is normally based in one office and is going to be working from another office for, let's say, 3 weeks, 2 weeks, whatever it might be, that's not a change to that person's normal working pattern. That's not something that the Home Office really want you to be telling them about.
Great. Somebody has asked, I've got my voice back now after having inhaled something a moment ago. I've asked about permissible visitor activities. What are they? I mean, they are they're published. So if you do a Google search on appendix visitor, Google that in, you'll find the relevant appendix to the immigration rules, which lists out the permissible activities, and essentially somebody must be falling within those activities. They are, largely speaking, what you term activities that are incidental to somebody's life and work outside the UK. So attending meetings, conferences, seminars, giving one-off talks, certain specific activities for researchers and academics in certain circumstances, things around, coming to attend court hearings, you're sort of the stuff you'd expect, the short-term, non-paid, non-substantive activities in the UK, and there is an exclusive list published. So that is what you have to refer to. And really, if something is not within that list of permissible activities, then the visa route as a visitor is not appropriate, and you'd be looking at the work-related routes as the alternative option. And what's unsatisfactory at the moment is that we've got a number of scenarios where really common sense would say, surely you can do this as a visitor, but because of the way the rules are, we're having to be cautious and move over to other categories. Hopefully that will be changed with these changes the government is talking about further down the line. Somebody else has asked about what are the requirements for making a sponsor license application. That's not something that can easily be answered in a few minutes. We can certainly help with that as your friendly legal advisors. We do sponsor licenses day in, day out, so we can certainly help point you in the direction of doing that, or indeed prepare the license application for you. Mark, any other final questions in the last few seconds before we sign off?
Yeah, the only other one to raise, we've had a couple of questions in relation to the actual process and using the sponsor management system to make reports. Just to be absolutely clear, when we've been talking about reporting changes throughout the course of this morning, the way in which that operates is you need to be logging on to your sponsor license through the SMS, through the sponsorship management system, navigating towards the workers section and actually selecting to report migrant activity. That then allows you to make the necessary report based on any change that might have been made to their circumstances.
Great. Well, that's just leaves me to say thank you very much for joining us. I hope you found it useful. Perhaps not as many changes as we've had in some previous sessions, but where that's the case, we'll always look to choose to focus on a topic or two of interest, as we have done today. Thanks for joining us. It's been great to have you with us, and hopefully see you or speak to you soon.